Hi, my name is Stephanie Alcala, and I'm going to give you some information as to what the process is to get divorced. I get a lot of questions from clients regarding what is the process? What do I have to do in order to get this going? So it's very, very easy. If we are in full agreement, this can be a very quick process. So there's 4 steps to this. The first step is filing the petition. The petition for dissolution is just a fancy way of saying divorce, can be filed with a court. Filing fee is usually about $500. It can be a little bit less depending if you e-file or file in person. So it just depends on what you're doing. You file the petition. Once you have a case number, you give this person what's called a service. So you have to file with the court the proof of service, and that is just a fancy way of saying that you handed the person these documents. So the person had the time necessary to review these documents and had notice. Basically, the court is not going to want to go forward on any case if you didn't tell the other person they're being the subject of a lawsuit. So it's regardless of what kind of case it is, you absolutely always have to notify the other party that there is in fact a lawsuit against them. So in this case, we're looking at a petition for divorce or dissolution. So you do have to let them know that there is a petition against them for dissolution that has been filed with the court. So it has to be a third party, not anyone that's part of the proceedings. So not you or your spouse. It must be a third party who's over 18 and who can sign the proof of service saying the time, date, and location that the documents were provided to the other party. This can be a family member, a friend. There's services that provide this. This is not usually a big deal. It's basically just handing the documents to the other party so that they are aware that a proceeding for dissolution is pending. So once they receive these documents, they have 30 days to file a response. The response usually has its own filing fee, usually the same thing. It's usually under $500, depends how you're filing it. If you're filing it through e-file or if you're filing it in person, the amount can vary, but usually $400 to $500 is what it's going to be. So there's also fee waivers. So you can request that they waive the fees, but you also have to show that that's actually necessary in your case if you don't have the funds to pay the filing fee. Okay, so once you file the petition for dissolution, you have served it, you have received a copy of the response, or you are in fact responding. It just depends on who you are. Then the next step is all parties have to interchange their preliminary declarations of disclosure. So basically, each party has to know what the other party has. So it's not fair to come to an agreement on property and how to divide it if you obtained property during marriage if the other party doesn't even know what they are. So the whole point of preliminary declarations of disclosure is basically where you have the ability to tell the court, I know that I'm coming to the table and making this agreement fully aware of what the property is and fully aware of what I'm doing in coming to this deal. So the next step after that is the other party provides these documents. You provide these documents as well. Once it's done, proof is given to the court through a proof of service that these documents have been exchanged. And then the next step is usually if we're able to come to an agreement, we can do a marital settlement agreement, an MSA. So what this means is that you guys have been able to come to an agreement and all of the terms of the division of the property is going to be in this contract, this agreement, this marital settlement agreement. Once that's signed by everyone involved, we will go ahead and do the judgment packet. So the judgment is basically the judge's orders, and usually the judge will just order whatever it is that you guys came to an agreement to. You'll sign it and boom, you're divorced. So it's completely possible to get this done within the 6-month California timeframe. They require in California at least 6 months, and this is for cooling off in case there's any kind of reconciliation, which the state is always going to be in favor of. So if you guys can reconcile your differences, the court is fine with that. You could just dismiss the proceedings. So either way, this process does not have to be long. It does not have to be tedious. Not all cases are going to be built like this. Not all cases are going to be so simple. There's going to be complicated cases where there's domestic violence restraining orders, where there's multiple motions through requests for orders. So this is not a one size fits all type of thing. But if you are able to come into an agreement, you want this to be over quickly, and the other party wants the same thing, then let's get the ball rolling in your case. If you have questions about your case, call us at 619-773-7333. My name is Stephanie Alcala. If you have any questions, we can always review your case, let you know what your rights are, what your property division looks like, and more or less what you can expect in these proceedings. Again, phone number is 619-773-7333.